Welcome to another edition of Question and Answer with a Criminal Defense Attorney. I'm Mark Solomon, a defense attorney in Denver, Colorado, and today's question is about arraignments. But before we get to that, don't forget to click like on this video if you're enjoying it and to click submit with a little bell next to it to be notified of future videos. What is an arraignment? And yesterday's video, which I will link to, yesterday's video was about pretrial conferences. Pretrial conferences come after an arraignment. We're going to do something that comes before that. The stereotypical arraignment is the first time you're in front of a judge, and that's where the judge has to give you certain advisements. So in Colorado, if it's a criminal case, they have to give you a protection order on your first appearance, and if you're in the court where your case is going to be heard. In other words, if it's a misdemeanor court, it's in county court, or if it's a felony level case and you're in district court, your first appearance in that court will be called an arraignment. And that is where the judge has to advise you of your rights. You have to be advised of your charges and the maximum penalties, and the expectation is that you're going to enter a plea, as in guilty or not guilty. If you plead guilty, which I almost never recommend at an arraignment, especially without negotiating some sort of a plea, the only thing the judge can do is either accept or reject the plea, and if he accepts that, then he can sentence you up to the maximum. So a lot of times, people come in front of the judge, they think they did something wrong. Some people have a problem pleading not guilty. We'll cover that in another video. But if you don't enter a plea, you can do what's called continue the arraignment. So when I write here, you enter a plea, not always. You don't always have to enter a plea. But if you do enter a not guilty plea, then that starts speedy trial, and we'll cover that in a future video too. So that's an arraignment. You get in front of the judge, he tells you what you've been charged with. So like, for example, he'd say, he or she, the judge would say, Mr. Smith, you've been charged with assault, 3rd degree. That's a class 1 misdemeanor with a maximum penalty of up to 24 months in jail and a fine. Do you understand that? You understand you have a certain number of rights, and usually in a lot of courts, they'll have you sign an advisement of rights, and the court won't go over each individual one, but they can sometimes go over every single one of your trial rights, especially if you ask them to do it. Otherwise, if you have an attorney, we'll often do what's called waive the advisement. In other words, if you're represented by an attorney, your attorney is expected to, and I know I always do, we go over every single charge that you're charged with, the definition, so those are the elements of what they have to prove, all of your rights for trial, all of your rights pre-trial, and at the other end of it, we waive that because we don't need the judge to tell the defendant all those things that I've already explained. So that's the question and answer for today. If you would like your own question in a future video, you can put it in the comments below, email it to me, or tag me on Twitter. And as always, you have a right to remain silent. If some police officer, law enforcement officer, anybody asks you any questions about what you have, where you've been, what you know, anything, you have a right to say, I don't want to talk to you. And if they persist, I want a lawyer.